what is claimed to be the prosecution incriminating evidence. I won't take up my time by showing you the second speech, but there is one. If I have time at the end, I will show it to you. So if you add to that another 10 speeches out of the 20 speeches on which the prosecution rely in its document containing the charges, after all, we are in a court of law and we rely on evidence. And what is the evidence that's produced of these speeches? 20 of them. 10 of them, I submit, and we will show this in the substantive part of our submissions, contain exonerating evidence which support the defence case theory. In other words, if you add the 10, which we've identified in the prosecution's 20, to our total of 35, we come to 45 speeches versus 10, which we say support the use of force only in self-defence. That is 350% more speeches in favour of our defence and 354% more reasons not to confirm the charges. And you can bet your bottom dollar that at the end of today's proceedings, either the victim's self-styled legal assistant to ICC counsel or a prosecution intern will be tasked with scouring the web, looking for the means to prove Kaufman wrong. And I will declare it, and I'll declare it loudly and clearly, as if the prosecution didn't know it already. It's not enough to state that since the former president made those extremely inflammatory statements and deaths occurred, that he must, as a matter of course, be criminally responsible for those fatalities. At this stage of the proceedings, the prosecution needs to show substantial grounds to believe that the former president actually desired and foresaw that people would be killed as a result of his incendiary language. For the prosecution to assert that Rodrigo Duterte hoped for deaths to occur or was recklessly indifferent as to whether deaths would occur, which he was not, that's insufficient. So once more for the record, Rodrigo Duterte's language was aimed not at suspected drug pushers as the prosecution would have it, but directly at those poisoning society with their substances, and not, I stress, with lethal intent. His rhetoric was calculated to arouse fear and obedience, to instill fear in their hearts, and to inculcate a respect for the law in their minds. Nothing more, nothing less. That was his intent, and it was not criminal. And as many of these drug pushers demanded to enter prison, I remember seeing the images on the television, lining up to surrender and to enter prison. Now, I challenge my colleagues opposite to prove otherwise, because as we all know, in a criminal process, the burden of proof is on the prosecution. They brought this case and they need to prove it. Rodrigo Duterte need not convince the world of anything, and that is to his fortunate advantage given his current medical condition. He stands behind his legacy resolutely, and he maintains his innocence absolutely. Now, I turn to the general fairness and objectivity of the investigation, which, as we all know, is meant to be an impartial evidence-gathering exercise. As an ex-prosecutor myself, I'm used to investigating agencies pursuing all reasonable lines of inquiry, assimilating all testimonies, and digesting all documentation and forensic evidence, recommending who to target for prosecution, but not so with this prosecution. When we, the defence, study the course of the investigation in this case, one thing is plain as a pikestaff. The chief prosecutor of this court, Mr. Karim Khan, not only failed miserably to carry out his duties under the Rome Statute, requiring him to examine exonerating circumstances as well as incriminating, but he single-handedly contaminated it, so we alleged, by pursuing a one-track crusade with a view to a predetermined objective. Let me explain. Although the ICC officially authorized an investigation into the so-called Philippines situation in late 2021, it was deferred a few months later back to the Philippines for the official investigation to resume only in late 2023. But the real meat of the investigation into count 1, relating to the activities of that fictitious construct, the Davao Death Squad, had effectively started way before then, with the sole objective of nailing Rodrigo Duterte. Indeed, all the way back in 2018, during its so-called preliminary examination, the prosecution had an individual who will be referred to as P1, handed to them on a silver platter. This P1 had been interviewed at an earlier date by none other than Chief Prosecutor Karim Khan, in his former capacity as a private lawyer, and the self-professed legal Rodrigo Duterte's role as the mobster-in-chief. The same her preparation. And what was this information with which Karim Khan had helpfully provided her? A book on which the prosecution relies as evidence. A trashy, scurrilous item of pulp fiction entitled Duterte Harry. Your Honours, the picture on the front cover of that book says it all. It really does scream objectivity, doesn't it? I say that sarcastically, of course. Fortunately for us, the defence, the appeals chamber, has now disqualified Chief Prosecutor Karim Khan from this case. A welcome development as a matter of ethical propriety, but in our opinion, too late in the day to salvage the integrity of the investigation that he had supervised. An investigation in the course of which he concealed his former role as the victim's counsel, who had deemed our client a suspected murderer as far back as 2018 and right up to the very day before this pre-trial chamber issued its arrest warrant. Your Honours, over the next few days, we hope to convince you of the wholly insufficient nature of the evidence against Rodrigo Duterte. We will show you that the paltry number of speeches on which the prosecution rely do not manifest criminal intent. We will also convince you that as hard as they tried, the prosecution's investigators couldn't get even one of its criminal cooperating witnesses, whose reliability is next to zero, to admit that they heard the former president, Rodrigo Duterte, give an order to kill at any time relevant to the charges, or with respect to any of the incidents. And we hope that when you conclude your deliberations, Your Honours, that you will dismiss these grievously misplaced and politically motivated charges. We will ask you to send Rodrigo Duterte back to his family, and we will ask you to give back to the Filipino people their tatay digong. Thank you, Your Honours.
The presiding judge. Thank you very much, Mr. Kaufman. We shall now suspend. This is the end of initial statements, and this is the end of this morning's hearings. We will take a 90-minute break and resume at 2 in the afternoon. Thank you very much.